What happens when a person works as a government employee his entire life and on his retirement he expects his pension to be his lifeline, but months turn into a year and the pension department simply doesn't respond. There is no rejection and no explanation, a simple wall of silence. This is where the power of a writ changes the game. In India, the Constitution is your shield. Under Article 226 for High Court and Article 32 for the Supreme Court, we can challenge the misuse or non-use of authority. The Writ of Mandamus is the proper remedy for this case. It is a direct intervention by the constitutional courts to ensure that a citizen of India doesn't get crushed by the authorities' ignorance, inaction, or arrogance. Mandamus is a judicial order compelling a public official to perform a duty they have ignored. For courts to grant a mandamus order, we have to prove 3 ingredients. You must have a statutory right to the demand, like in this case, the right to a pension. Next is that the department must have a legal obligation to act. But remember, the writ of mandamus is only applicable for public authorities. It is not applicable against any private entities. You will have to show that you have made a formal written request to the authority and that the authority has failed to act upon it within a reasonable time. While we use the pension case as an example to understand the writ of mandamus, this is applicable to other government departments as well. The writ of mandamus is applicable for any government official for their inaction, such as in service matters, the electricity department, the police department, or any government official to compel them to act upon their duty. Mandamus is perhaps the most practical tool for administrative accountability. It reminds the system that no office is above the law. If you are facing a wall of silence from any department being a public authority, then the law can command them to speak. Stay informed, stay empowered.